morning, everyone, and thank you for joining us today. I am Miriam Benitez, one of the partners at VWV and the partner advising mainly on school-related matters, parent and pupil matters. And with us, we also have Catherine Harris. Catherine, would you like to introduce yourself briefly?
Yes, of course. Hi, everyone. My name is Catherine Harris. I'm a solicitor in VWV's regulatory compliance team, and I assist on education law matters.
Thank you, Catherine. So in the first slide, you'll find the agenda. Tamer, please, can we move on to the first slide? Thank you. So that's the agenda for today's seminar. We're going to talk about offsite directions, how we define those, what they mean in law and in practice, practical considerations. We will then be looking at managed moves and what those mean, and again, practical considerations of managed moves and dual registration in relation to both. There will be time, we're hoping, for Q&A. And again, I ask you please to post your questions on the Q&A facility rather than the chat. So before we move on to the first section of this talk, I just wanted to emphasize how important it is to get it right in relation to managed moves and offsite directions. We are seeing an increase of challenges against permanent exclusion, particularly where managed moves and offsite directions have not been considered as alternative to what is considered a very last resort, and that is a permanent exclusion. You have the statutory guidance of August 2024 in relation to suspensions. You will all be very familiar with that. We have also had this summer the school attendance regulations, and I will be touching on those in the section on dual registration. We know from the various pieces of DfE guidance that there are three main aims to any response to misbehavior. The first one is deterrence, as we all know. The second one is protection of the staff and pupils, including the pupil who is misbehaving. And the third one is improvement. Managed moves and offsite directions fall within mainly the third category, that is, of improvement, and are not considered sanctions under the guidance, but rather a way of supporting the pupil's journey towards improving their own behavior and understanding their own behavior. And that is why both come under the section in the suspensions guidance on preventative measures to exclusions for suspensions and permanent exclusion. We regularly receive queries in relation to all these three issues, particularly when they interrelate and what happens with permanent exclusions, if a pupil is a managed moves, etc. We'll be touching on those. Catherine, would you like to start your section then? Thank you.
Yeah, so first of all, looking at offsite directions. Next slide, please. Thank you. So an offsite direction is when a governing board of a maintained school requires a pupil to attend another education setting to improve their behaviour. And in terms of the legal basis for this, the governing body of a maintained school has the statutory power for this under Section 29A of the Education Act 2002. It's important to note that this legislation does not apply to academies, although it is generally accepted that academies can arrange off-site provision for such purposes under their general powers, which are set out in the Academy Trust's Articles of Association. In terms of the requirements for an off-site direction, the governing body of a maintained school must comply with the Educational Provision for Improving Behaviour Regulations 2010, as amended by the Educational Provision for Improving Behaviour Amendment Regulations 2012. And these regulations contains obligations relating to the management and review of off-site education. Maintained schools must also have regard to the Department for Education's guidance on alternative provision statutory guidance for local authorities, which provides guidance on the requirements set out in the amended regulations. As with Section 29A of the Education Act, the amended regulations and the alternative provision guidance do not apply to academies, but they can provide academies with an example of good practice, and academies are encouraged to follow these. Guidance on offsite directions, as well as managed moves, which Miriam will come on to talk about later, are also set out in the Department for Education's statutory exclusions guidance, as they should be considered before an exclusion is imposed to reduce the likelihood that an exclusion will be needed. I just wanted to flag as well that some proposals under the Children's Wellbeing in Schools Bill relate to offsite directions. So the bill, as I'm sure you'll all be aware, is a proposal for new laws aimed at protecting children and improving education. And it proposes a number of key changes in relation to education, including extending the Section 29A statutory duty to academies, and that would place academies on the same statutory footing as maintained schools when it comes to directing off-site. In reality, however, this change is unlikely to result in any significant change to current practice for academies, and that's because academies are already encouraged to have regards to the alternative provision guidance. Next slide, please. So looking at the purpose for an off-site direction, really importantly, an off-site direction can only be used as a way to improve future behaviour. So it should not be used as a sanction or punishment for past misconduct. It should also only be used where in-school interventions and/or outreach have been unsuccessful or are deemed inappropriate. So it's really important that before directing off-site, the school has considered and implemented other measures to manage the pupil's behaviour on the school site or with outreach if appropriate. Depending on the individual needs and circumstances of the pupil, off-site direction can be full-time or a combination of part-time support in alternative provision and continued mainstream education. And during the off-site direction, a pupil must be recorded in the attendance register using code D, and that's the code that is used to indicate that the pupil is absent with leave to attend the other school at which they are registered. Next slide, please. So looking at the time limits for an off-site direction, one of the important requirements for them is that it is a time-limited placement that's used as part of planned intervention to support a pupil. So really importantly, it should only be used as a temporary measure. The guidance does not specify a time frame, but it must not be for longer than is necessary to support the aims of the placement. And the length of time that a pupil spends in another mainstream school or alternative provision after being directed off-site will really depend on what best supports the pupil's needs and potential improvement in their behaviour. A proposed maximum period of time should, however, be discussed and agreed upon as part of the planning phase for an off-site direction, and that should be carefully linked to the objectives for the pupil during the placement. As it says on the slide, the off-site placement can be shortened or extended depending on the pupil's needs and effectiveness of the placement. And something that will be discussed as the placement is being reviewed, which we'll come to look at shortly. The focus during the off-site direction should remain on ensuring that a child continues to receive a good education that's on par with their mainstream peers, whilst the needs which require intervention are also being addressed. So really importantly, once the off-site placement has ended, it's the intention that the pupil will return to the home school. As I said, an off-site direction is only a temporary measure. But if it turns out that it's not in the pupil's best interests for the pupil to be returned to the home school, then alternatives can be considered, and that includes a managed move on a permanent basis. But this cannot be the objective of the off-site direction, and a managed move must be entirely voluntary by the parent and pupil. And as I said, Miriam will come to talk about managed moves shortly. Next slide, please. So looking at whether or not parental consent is needed for an off-site direction, unlike for managed moves, there's no need for parental consent for the off-site direction, as it's only a temporary measure to support a pupil's behaviour and reduce the likelihood of a school exclusion. Under the amended regulations, however, Parents or pupils aged over 18 or over, sorry, and the local authority, if the pupil has an education, health and care plan, they must be notified in writing and provided with information about the placement as soon as practicable after the direction has been made, and by no later than 2 days before the relevant day. And the relevant day in this context is the first day on which the pupil is required to attend an off-site placement. And the prescribed information which maintained schools must provide under the amended regulations to parents, pupils, and or the LA, and which academies would be encouraged to provide, is set out in a later slide. But this would include the need to provide clear information on why, when, where, and how the offsite placement will be reviewed. And that's to ensure that it's a collaborative process with the parents' involvement to lead to the maximum support possible for the pupil. Next slide, please. Looking now at reviews during an off-site placement. So another requirement under the amended regulations and alternative provision guidance for off-site directions is that the placement must be kept under review and that the parents are involved in the review process. The regulations specify regular reviews, but they don't specify how often the reviews must take place. And this should therefore be decided on a case-by-case basis and should be frequent enough to provide assurance that the off-site education is achieving its objectives and that the pupil is benefiting from it. There are a few requirements for the governing bodies of maintained schools in relation to the reviews of off-site directions, and academies are also encouraged to follow this. So the first is that by not later than 6 days before the date of any review meeting, parents and the local authority, if the pupil has an EHC plan, must be given a written invitation to attend the review meeting or to submit in writing before the date of the meeting their views as to whether or not the off-site direction should continue to have effect. Insofar as is practicable, any review meeting must be convened on a date and at a time that is suitable for the parent. Parents or pupils aged 18 or over and the local authority where the pupil has an EHC plan can also request in writing that a review meeting is held. And when this happens, the governing body must comply with the request as soon as is reasonably practicable, unless there has already been a review meeting in the previous 10 weeks. Review meetings should take place between the school, parents, the pupil, and other agencies. So, for example, if the pupil has a social worker, they should attend the review meeting. Relevant agencies might also include someone from CAMS, multi-agency safeguarding hubs, so MASH, and youth justice teams, and also the local authority if the pupil has an EHC plan. And that's so that everyone can establish agreed monitoring points to discuss the pupil's ongoing behavior. The reviews should be recorded in writing and be frequent enough to provide assurance that the off-site direction is achieving its objectives. And there is also the requirement that the governing body of a maintained school must give written notification of their decision as to whether or not the requirement for the off-site direction is to continue, and if so, for what period of time, including the reasons for this, to the parents by no later than 6 days after the review meeting has taken place. Next slide, please. Looking now at pupils with an EHC plan. So in terms of directing a pupil off-site where the pupil has a EHC plan, this isn't unlawful, but it must be in the pupil's best interests. And in the context of behaviour, where a pupil has an EHC plan, misbehaviour should be considered as some kind of unmet need. So the response from the school must never be a sanction in the first instance, and reasonable adjustments should be made to the school's behaviour policy as appropriate, whilst the school should also consider whether further support is needed for the pupil. Before directing a pupil with an EHCP off-site, the pupil should also contact the local authority at an early stage and consider requesting an early annual review of their EHC plan. If the school does decide to direct off-site, the legal duties on the local authority and the home school continue to apply throughout the off-site placement. So that includes duties under the Equality Act 2010, for example, to make reasonable adjustments, and also under Section 66 of the Children and Families Act 2014, which is that the school must use its best endeavours to secure that the special educational provision called for by the pupils or students' special educational needs is made. So as Section I of the EHC plan names the homeschool still has the duty under Section 66 of the Children and Families Act to deliver the provisions set out in Section F of the plan during the offsite placement. And the homeschool must therefore be satisfied that the Section F provision is being provided to the pupil during the offsite placement, as the Section 66 duty does not cease during the offsite direction. So there should be no disruption to the special educational provision for the pupil. And this is the case whether or not the local authority agrees, as the EHCP is a statutory document. So as I said, the local authority should be contacted at an early stage about the offsite direction and must be informed of the placement. As I've already said as well, where a child has an EHC plan, by no later than 6 days before the date of any review meeting, the local authority, as well as the parents, must be given a written invitation to attend the review meeting or to submit their written representations about the placement. And as well as this, where a pupil has an EHC plan, the local authority, as well as the parents, can also request in writing a review meeting, which must be complied with unless there has already been a review meeting in the previous 10 weeks. Next slide, please. Looking now at reintegration after an offsite direction. So really importantly, as I've already said, once the placement has come to an end, it's the intention that the pupil will return to the home school. And schools should therefore support pupils to reintegrate successfully into school life and full-time education following a period of offsite direction. There is a lot of information in the statutory exclusions guidance on reintegration following both a suspension and an offsite direction. So I'm not going to go into lots of detail here, but the key point really is that there should be a reintegration strategy. And as shown in the excerpt on the slide, and that's an excerpt taken from the DfE statutory exclusions guidance, a reintegration strategy should be designed to offer the pupil a fresh start, to help them to understand the effects of their behaviour on themselves and others, to teach them how to meet the high expectations of behaviour in line with the school culture, to foster a renewed sense of belonging within the school community, and also to build engagement with learning. The reintegration strategy should also be clearly communicated at a reintegration meeting that should take place either before or at the beginning of the pupil's return to the home school. And where possible, this meeting should include the pupil's parents, but at the same time, it's important to note that a pupil should not be prevented from returning to the home school and to a mainstream classroom if the parents are unable or unwilling to attend the reintegration meeting. To ensure an ongoing process, the reintegration strategy should be regularly reviewed and adapted where necessary throughout the reintegration process, and that should be in collaboration with the pupil, the parents, and other relevant parties. The exclusions guidance also lists a range of measures that schools can use to enable the pupil's successful reintegration following both a suspension and offsite education. And some of these include maintaining regular contact with the pupil during the offsite direction, and also ensuring that the pupil follows an equivalent curriculum during an offsite direction or receives academic support upon return to catch up on any lost progress. Just to say as well that the alternative provision guidance says that the governing body of a maintained school should obtain from the provider, so that's the provider providing the offsite placement, a final report on the pupil's achievements during the placement that includes information on academic attainment and progress, attendance records, and evidence of change in behaviour. And the governing body should also seek the pupils' views on the success of the placement, and this might assist the homeschool in deciding if and when to use that provider to support other pupils. Next slide, please. So as I said at the beginning, the only legal basis for directing offsite direction is to improve a pupil's future behaviour. Isn't it? I just wanted to flag that there is case law which supports directing offsite for safeguarding reasons, and specifically that's the 2021 judicial review case of Newark, where the High Court found that a maintained school and the local authority did have the power to direct offsite sites for safeguarding reasons. And this was after there was alleged child abuse from a boy at a primary school towards other female pupils, and the school and the local authority decided to direct the alleged perpetrator off-site for safeguarding separation. The facts are on the slide, so I'm not going to go into any great detail, but the key point here is that this case relates to a maintained school, and whilst the High Court found that a maintained school and the local authority did have the power to direct offsite for safeguarding reasons, whether or not an academy would have a legal basis on which to direct offsite for safeguarding separation has not yet been tested in the courts. Next slide, please. Just to say as well, as this slide references, that this case is also very fact specific. So it was a case involving, as I said, alleged child abuse, and the school in the case was very small. So there was only around 200 pupils, and there was only one very small corridor in the school. So it might not be considered to be lawful to direct a pupil off-site where something similar happened in a larger school, as it would be easier in a larger school to obviously keep alleged perpetrators separate from the victims. So we'd obviously advise that you seek legal advice if you are considering directing offsites for safeguarding reasons. Next slide, please. So obviously the parents might have some concerns if the school decides to direct offsites to improve a child's future behaviour. Some of those concerns might include whether or not the placement is meeting the needs of the pupil, whether or not it's being reviewed at appropriate intervals, and whether the placement offers the pupil a broad and balanced curriculum. So our next few slides is just going to discuss some top tips for corresponding with the parents about an offsite direction. So next slide, please. So as I said earlier, for maintained schools, the governing body must ensure that parents or pupils aged 18 or over and the local authority, if the pupil has an EHC plan, are notified in writing and provided with information about the placement as soon as practicable after the direction has been made and by no later than two school days before the first day on which the pupil attends the offsite placement. This requirement is set out under Regulation 3 of the Educational Provision for Improving Behaviour Regulations 2010 as amended. And this includes the need to provide clear information on the address at which the provision is being provided, the information of the person to whom the pupil should report at the offsite direction on the first day, the duration of the offsite education, reasons for and objectives for the direction, and also the times at which the sessions start and end, depending on whether there are there is a single or two sessions per day that the pupil will be attending at the offsite placement. So for maintained schools, they must set this information out to parents, and academies are also encouraged to follow this. Next slide, please. Some other information that we would suggest is included in correspondence with parents about an offsite direction would also be whether or not the proposed placement is full-time or part-time, what interventions the school has already put in place to address the pupil's behaviour, information on behaviour incidents that have occurred since those interventions to support the school's case for an offsite direction, and how the offsite direction is in the pupil's best interests in the context of any additional needs. Next slide, please. Other information will include what the specific measurable aims are for the placement, what the arrangements are for the regular reviews of the placement, how the school will continue to have oversight of the student during the placement, practicalities for attending the temporary school setting, and that the legal duties on the local authority and the school will continue to apply throughout the placement. So that's an overview of requirements for offsite directions. And I'm now going to pass on over to Miriam so she can talk about managed moves.
Thank you very much, Catherine, for that very comprehensive overview of offsite directions. We have questions in the chat, and I will assume that all questions up to question 8 are in relation to offsite direction, and we will aim to answer this after my talk. If we don't have time to answer them, then we will provide you with a written answer to all of the questions, and this will be distributed with the slides. So moving on to managed moves then, the first slide is about how we define a managed move. So a managed move is not defined in law. It has grown out of informal arrangements. It's permanent. It's a permanent transfer to a new school. It is supposed to be a fresh start for the pupil to see, well, to attempt to address the underlying roots of the behavior and to give them a new school environment within which to be supported. So because it is permanent, there should never be any reference to a trial period anywhere in relation to a managed move. There should be no reference either in conversation with parents or in conversations with the school that has taken on the pupil or in conversations with the local authority. So everyone must be clear that a managed move is a permanent measure. A managed move cannot be cancelled by the receiving school in any circumstances. The only circumstances in which a pupil can come off the admission register of the receiving school is where the pupil has been permanently excluded. And I will come on to talk about that a little bit more later on in the talk. The managed moves must be voluntary and agreed with all parties. And this includes, of course, the agreement of the parents. And it's very important to be able to show a documentary or an evidence trail of the parental agreements in relation to a managed move. It's not unusual that we see schools to say, well, the parents agreed, we effected the managed move, and then the parents said that they hadn't in fact agreed or that it wasn't informed consent, etc. So it's very important that you keep your own records in relation to the conversations that you have with parents, whether that's minuted meetings or emails summarizing the conversation with parents and asking them for their agreement to the managed move in writing. I cannot emphasize enough the importance of this in the context of Ofsted, who will issue an inadequate judgment on schools that have been found to be pressurizing parents into managed moves. And the managed moves must only occur when it is in the pupil's best interest, and that will include a very wide range of considerations, including disability, special educational needs, family circumstances, local arrangements, etc. So you have to have a very, very wide consideration of all of these issues before you come to decide that a managed move would be in the pupil's best interest. Next slide, Taima. So continuing on to the definition of a managed move cannot break down, and the pupil cannot be sent back to the receiving school for a behavior infringement if the receiving school has not issued a permanent exclusion. And I want to make this clear because this is one of the questions that comes through our email inboxes almost on a weekly basis. So if you have placed a pupil on a managed move with the agreement of the family, the pupil that misbehaves at the receiving school, it is for the receiving school to decide how they're going to treat that behavior in accordance with their permanent exclusion. They can't ask you to take the pupil back in any circumstances. So if the behavior is sufficiently serious that it may warrant a permanent exclusion, that's a decision for the receiving school to make. Now, if the pupil is still registered at the home school could consider whether the behavior that has taken place off-site amounts to a serious breach of their own behavior policy. within the school. There are some problems with this for the home school. Obviously, that the first problem is that they wouldn't have conducted an investigation and wouldn't be appraised of all of the facts at the receiving school. They can ask the receiving school for the investigation report and everything related to the behavior at the home, at the receiving school, and then come to a view. But I will talk later as to this shouldn't be happening if you comply with the school attendance regulations and in relation to deletion of a child's name from the register and insertion in the register of the receiving school. I've inserted there the definition in the guidance. A managed move is used to initiate a process which leads to the transfer of a pupil to another mainstream school permanently. The word process in this context is somewhat problematic, and I think this is why some schools understand this as a trial period, particularly the receiving schools. There is no trial period. Once the child moves to a school on a managed move, that is a permanent move, and the child will have to be entered in the admissions register. Next slide, please. Now, this is simply an overview for you to consider all of the guidance and the regulations that are relevant to the issue of managed moves. I'm not going to pause on this. It's quite important. The last item in here relates to the guidance to parents in relation to school behavior and exclusion. There is reference within that to managed moves and also to offsite directions. I always advise my clients that when writing to a parent in relation to a managed move, they insert a link or a PDF of the guide for parents, so the parents are fully informed of their decision and they have the relevant context. Next slide, please. So in relation to the context for managed moves, the requirement in the suspensions guidance is very much to consider alternative measure to school exclusion. So you always have to look at what alternative measures that may be that can avoid that exclusion, and within that, a managed move should be at the very end of that consideration. You also have to look at the initial interventions that you can find at page 27 of the Behavior in Schools Guidance, where examples are given as to what interventions you must consider before you move on to considering a managed move. In most circumstances. So that will include, for example, engagement with parents, home visits if necessary, mentoring and coaching, additional mental health support, short-term behavior report cards, longer-term behavior plans, positive behavior plans, pupil support units within the school as defined in the Behavior in Schools Guidance, engaging with other local partners, whether that's local authorities or education psychology service, etc. And also initial intervention should include an assessment of whether appropriate provisions in place to support a pupil that may have a special educational needs. And within that, you have to follow as a school the graduated approach and the code of practice. So the emphasis is very much on permanent exclusion as the last resort. And the idea is that a managed move is there to minimize disruption to a pupil's education as far as possible. Moving on to the next slide. I wanted to pause briefly on two cases. One was decided quite a while back in 2017 when the suspensions guidance was slightly different from what it is now. And the second one, the case of LM against an unnamed Academy trust, was very recent. It only came out this summer in mid-July 2024. In relation to the first one, this was a judicial review against a decision of an independent review panel which upheld a head teacher's decision to issue a permanent exclusion. In this case, the year 6 pupil had slapped another pupil and displayed other challenging conduct during this incident at school, including slamming of doors, etc. During a meeting with the family, the head teacher told the family that there were two options on the table. One was to permanently exclude, and the other one was to sign a form requesting a managed move to another school. Now, during that meeting, the majority of the discussion revolved around the conduct and how that conduct came within the policy, within the remit of a permanent exclusion. And very little time was devoted to actually discussing what a managed move would entail and the details of the managed move and the benefits to the child of the managed move. There was no discussion, for example, of how the managed move would be in the child's best interests. The parent declined to sign the form at the meeting and then received a letter saying the head teacher has made a decision to permanently exclude the pupil. The independent review panel upheld the head teacher's decision and found that the head teacher had sufficiently considered the issue of the managed move, but the parents had declined, and therefore there was nothing that the head teacher could do. The High Court disagreed with the independent review panel and set aside their decision. They said that whilst the head teacher had raised the issue of the managed move at the meeting, the head teacher had not sufficiently explored the issue with parents, had not explained why it would be in the best interest, what considerations had been taken into account, what would happen as a result of the managed move, etc. And therefore, the court found that this communication with parents did not satisfy the requirements in the suspensions guidance for parents to make an informed decision on whether or not to accept a managed move. Now, the importance of this case is that it has been quite often relied on by those who are seeking a judicial review of independent review panels, families that are seeking a judicial review of independent review panels, insofar as it talks about managed moves and not having considered it as an alternative measure before issuing a permanent exclusion. That was again revisited in the case of LM and an Academy trust in the summer of 2024. And it was argued there that the GDC in that case had acted irrationally, in concluding that permanent exclusion was a last resort because there was no evidence that alternative had been properly explored. In that case, the family argued that the head teacher had actually not provided sufficient evidence, written evidence, basically a documentary trail of any decision-making or considerations in relation to the managed move, and that therefore they had sabotaged any opportunity to explore an alternative placement because this had not been sufficiently raised with the family. The court disagreed with the family and upheld the independent review panel's findings that the head teacher had sufficiently considered a managed move. In this case, however, the head teacher had a very comprehensive statement that was submitted to the GDC with the specific sections on managed moves and how this had been considered and raised with the family, etc. And the independent review panel had accepted the head teacher's account and found the head teacher to be credible and reliable in relation to the managed move inquiries that had been taken into account. For example, the head teacher gave details of all of the conversations with dates and times that had taken place with other schools, of the conversations with the family, etc. So I guess what I'm trying to say with this case is that the head teacher's assessment of a managed move had to be particularly comprehensive in relation to that consideration of alternative strategies, and therefore the court did not interfere with it. So it's just very important that head teachers, when looking at the matter of managed moves, they conduct that very comprehensive analysis that they can then show has been conducted either by notes or emails, telephone calls, etc., or a summary thereof provided to the GDC when the permanent exclusion is appealed or when parents want an explanation. Thank you. Next slide. So Just to summarize the considerations before a managed move takes place, it has to be considered as part of a planned intervention. So you have to look at page 27 of the Behavior in the Schools guidance and determine whether you have undertaken all of those steps prior to consideration of a managed move. And the school, the home school, should be able to evidence appropriate initial intervention for the root cause of the behavior prior to the managed move, whether that is a multi-agency support, statutory assessments, or in-school support and intervention, or even outreach strategies. Moving on to the next slide. In relation to pupils with EHC plans, similar considerations apply to those raised by Catherine in her talk. It is not per se unlawful, but it must be in the pupil's best interest. All parties must be involved and must give their agreement to a managed move, particularly the local authority and parents where the child has an EHCP. The legal duties on the school and the local authority to continue to apply throughout the managed move process. So it has to be even more seamless than in a case where you don't have an EHCP, to ensure that the Section F provision continues to be delivered even during the initial period of the placement in the receiving school. Everybody has to be ready to hit the ground running, in essence, and make that provision in Section F. And then the local authority must be invited to follow the relevant statutory procedures for amending an EHCP to name a different school provision in Section I. Moving on to the next slide. With regards to information sharing on managed moves, the suspensions guidance is quite clear on the information that has to be sent to the receiving schools as data on prior and current attainment, academic potential, risk assessment and advice on effective risk management strategies tried to date. And also the new school should ensure that the pupil is provided with an effective integration strategy, and the home school can instigate that at the outset to make sure that their pupil is going to be received with everything in place from day one. As with offsite directions, there can be parental concerns in relation to managed moves, and that takes me on to the next slide. So if a parent believes that they are being pressured into a managed move or unhappy with it, they should always be directed to the school's complaints policy. They can also complain to the local authority, in particular where a child has an EHCP. So if a parent at any point raises with the head teacher or with any other member of staff that they may be feeling under pressure, it is really important to send out that complaints policy and to seek to clarify with them first informally under your complaint procedures, and then formally if necessary, whether in fact they wish to make a complaint against the managed move. This will provide the school a measure of protection should the parents then agree to the managed move, and once they're at the new school say that they never agreed to the managed move, etc. It goes back to making sure that everybody understands what a managed move means and when it should be considered and suggested to the family. And I have inserted there paragraph 52 of the suspension and permanent solutions guidance, again, in relation to of rolling, and you can see that the threshold is quite low. It says that Ofsted is likely to judge the school as inadequate on the basis of evidence of a parent having been pressured into a managed move that resulted in the pupil's name being deleted from the register. Next slide, please. So in relation to correspondence with parents, I've already been talking quite a bit about that. It's important to provide them with a guidance that I have inserted in one of these slides in relation to guidance device for parents, specifically by the DFE. It's important to remind them of the fact that it's a voluntary decision and that their agreement is necessary for the managed move, so that everyone is clear on this point. It is also important to set out why the school considered that a managed move would be in the best interest of the pupil. and clarify that it is a permanent transfer from day one of the managed move, and that the pupil's name will be inserted in the register of the receiving school. You can give details in that initial communication in relation to the managed move on the integration strategy at the receiving school and what support the pupil can expect. It is good practice to insert in that communication the name of a member of staff who will be supporting the pupil at the receiving school, and the name and contact details of a member of staff at the receiving school that parent can get in touch with should they have any concerns from day one. That will provide parents with some reassurance that they're not simply left to figure out how the new school works, etc., and who to contact. And then there are some admissions register practicalities, which we'll come to talk in the next section of this talk. Next slide, Tamer, please. So we come to look at the issue of dual registration. And if we look at the first slide of that, of this section, so during offsite and managed moves, pupils can be dually registered and will be dually registered, specifically in relation to offsite. So looking first at offsite, you have so paragraph 231 of the Improving Attendance in Schools guidance that says that where it has been agreed between the school and a person with the pupil's attendance that the pupil will be registered at more than one school, the pupil's name will remain on the admission register of the home school and will also be entered in the admission register of the receiving school. And it gives the main examples. It says the main examples of dual registration are pupils who are attending another school on a temporary basis, such as a pupil referral unit, a hospital school, or a specialist school. It also talks about pupils who are being educated off-site and the need for dual registration in those instances. So unfortunately, the improving attendance in schools guidance is not as clear as it could be, regardless of the length of the offsite direction, and there is no upper limit or lower limit on how long offsite directions can be. The pupil's name has to be entered in the admission register in the usual way, insofar as the pupil will be attending that school either on a full-time or a part-time basis, and can only then be taken off the register and the circumstances that we're going to come to look at in a minute. So in relation to managed moves, so good practice is that the name of the pupil moving schools will be entered in the register of the receiving school from day one, and it will be then deleted from the home school immediately with the consent of the parents. If we can move on to the next slide. So these are the circumstances where a pupil's name can be deleted, lawfully deleted from the admissions register. The deletion from the home or receiving a school's admission register may only take place where two circumstances that are applicable to this talk. There are other circumstances within the regulations, but I'm not going to stop on all of those, and they're not applicable to managed moves or offsite directions per se. So the first one is where the home school or the receiving school imposes a permanent exclusion. That's regulation 910. So where the receiving school imposes a permanent exclusion, they can delete the name from the register. If the pupil's name is still in the register of the home school, then the pupil would go back to the home school unless the home school decides to permanently exclude on the basis of offsite behavior and what they know of the incident at the receiving school, in which case they would have to issue a permanent exclusion before they can remove from the register. Where the pupil is dual register, so that the second scenario is where the pupil is on the register at two schools. And then the following conditions must be satisfied. So that is, the home school does not have reasonable grounds to believe that the pupil will attend the home school again. And each school where the pupil is registered has given consent to the deletion. There is no school attendance order naming the school informs in relation to the pupil, and the pupil is not a mobile child. If they are, the school is not their main school, and that's Regulation 91C. I should also add that you must not delete the name of a pupil from the register unless the local authority, if the pupil has an EHCP naming your school, unless and until the local authority amends Section I of the plan, naming the new school, the receiving school in Section I. So there is a question mark over managed moves and how long is it reasonable for the the home school, to maintain the name of the child in the register. My advice always is as short as possible, given that a managed move is a permanent solution and a permanent transfer to another school. And in accordance with the guidance, the home school should have, or the other way around, I should say, it should not have reasonable grounds to believe that the pupil will attend the home school again, precisely because what the suspensions guidance of August 2024 tells us is that a managed move is a permanent solution, and therefore the home school should be able to delete the name from the register, provided that all the other circumstances have been satisfied, so that each school where the pupil is registered, that would be in this case, the receiving school, has given consent to the deletion, and there is no school attendance order, etc. Next slide, please. So during the dual registration period, we've talked about this already. If the receiving school excludes permanently the pupil, the home school cannot delete the name of the pupil from the register on the grounds of that permanent exclusion, unless they make a separate decision themselves on the basis of the suspensions guidance, and only the school that imposes the PECs can delete from the admission register.